Stand up, stand up. Stand up for your rights.
Aloha, Hawaii. I'm attorney Andre Wooten. And over the past 2 decades, I've had the distinct pleasure to represent scores of people who have been victims of negligent drivers upon the roadways of the various parts of the state of Hawaii. Consequently, I know that, as you know, Hawaii is what we call a no-fault state, which is distinct from the other states which are called liability states. No fault means in Hawaii that the initial medical bills of a person who has been the victim of a negligent driver are to be covered by the insurance policy on the vehicle involved in the accident. That certainly means that the person who has purchased the motor vehicle insurance policy is covered by the insurance policy, as well as every regular member in the household, as long as that person is under the age of 22. Also, passengers who are in the vehicle are also covered by the no-fault insurance policy, and pedestrians who may be struck by a vehicle in Hawaii are also to be covered by the minimum $10,000 medical insurance benefit policy that is required to be a part of every no-fault policy in the state of Hawaii. In order to lower the no-fault benefits for motor vehicles in the state of Hawaii, in 1997, the Hawaii State Legislature amended the law and made certain important changes. Certain benefits in the policy were made mandatory, meaning that every insurance policy in the state of Hawaii had to have the medical insurance benefit for victims involved in collisions up to $10,000, but certain other provisions were made voluntary, meaning that the individual could select them. One of those voluntary provisions is the wage loss replacement policy. That means that should a person be rendered unable to work as a result of the injuries suffered in a motor vehicle accident for which they're covered under insurance, if they have selected and purchased the wage replacement benefit, those lost wages should be paid to them on a regular basis pursuant to the insurance policy. In one particular case, the case of First Insurance versus Angel Doyen, Mr. Doyen purchased a no-fault motor vehicle policy from First Insurance, and Mr. Doyen was subsequently, unfortunately, disabled in an accident and unable to go back to work. Mr. Doyen was disabled for 7 years, and when he turned 65, First Insurance made a declaratory motion in court to cease paying the $1,500 a month in lost wages replacement benefits that were under the policy. The state Supreme Court said no, that First Insurance was obligated, based upon the language of the policy, to continue to pay Mr. Doyen as long as his doctor certified him as disabled, as long as he shall live. Consequently, you can see that it is very beneficial to check the coverage box in the optional coverages. Another important optional coverage is uninsured motorist coverage. For a few dollars, a person can obtain coverage should they be hit by a driver who is not covered by insurance. That can provide all of the difference in the world between a full recovery and a non-recovery. If a person is facing a situation where the liable party had no insurance, they can then make a claim for payment of their pain and suffering and physical damage, injuries upon their own insurance. Another optional policy that any citizen is well advised to check off and obtain is underinsured motorist coverage. Underinsured motorist coverage comes into play when a person is seriously injured in an accident whose fault was caused by another driver, but that other driver, although they may have some insurance, that insurance does not cover all of the sum total of the physical and property damages of the injured party. And if the person has checked underinsured motorist coverage under their own policy, then they can make a claim for the difference between what the insured person's policy will pay and the total damages that the person should be paid to be made whole. Caveat, though, in claiming underinsured motorist coverages, one is always best advised to notify their own insurance company first before they sign off on a settlement provision. Many insurance policies do not state this in bold language, and people are sometimes rudely awakened when they claim their underinsured benefits from their company. If one does not obtain $5,000 in medical bills, then their injuries are not considered serious and they are not able to file suit or make a settlement with the insurance company. If you have been the victim of a serious injury and accumulated at least $5,000 in medical bills, then you are eligible to file suit to recover for your physical injuries and special damages. And it would behoove you to obtain the services of an experienced legal professional in order to put a demand package together to assert your rights to all of the aspects of recovery that you're eligible to receive. Aloha, I'm attorney Andre Wooten. People have needed professional legal help since the dawn of civilization. If you have been injured on the public roads in the state of Hawaii and you need help defending your legal rights,